Good afternoon, everybody. I'm Erin May Quaid. I'm the Advocacy Director at Gender Justice. Welcome to a victory for abortion rights in Minnesota. We're going to talk about the litigation that ended with summary judgment and how we have several abortion restrictions in Minnesota that are now blocked in our state. Joining me today is Megan Peterson, the Executive Director at Gender Justice. Megan, go ahead, say hi.
Hi, everyone. Happy to be here. I use she, her pronouns.
Papis, go ahead and introduce yourself.
Hi, everyone. I'm Papis. I'm a litigation counsel with the Lawyering Project. I use he, him pronouns, and it's great to be here with everyone.
Awesome. Abina?
Good afternoon, everybody. I'm Abina. I'm the Unrestrict Minnesota campaign director, and I use she, her pronouns.
Shayla?
Peace, everybody. I'm Shayla. I'm the executive director of Our Justice. All pronouns are cool with me.
And Christy?
Hello, everyone. Excited to be here. My name's Christy Boris. I'm a physician and abortion provider here in the metro area, numerous places actually. My pronouns are she, her.
Wonderful. For all of those who are joining us today, if you have questions, please enter them into the Q&A box. We'll make sure to answer your questions throughout and certainly at the end. Thank you all for joining us. I'm just going to get us started. I'm going to share my screen and we're all going to pretend that my screen isn't chaos. There we go. So I'm going to start by talking a little bit about the history and strategy behind the case that, removed most of the abortion restrictions in Minnesota. To start with that, I want to start with some history about where we are in Minnesota, or where we were with abortion rights. So in 1995, there was a Minnesota Supreme Court case called Doe v. Gomez. And the question before the court was, can the Minnesota legislature prohibit the use of taxpayer dollars from paying for abortion care and related services when it had established that it would use those same taxpayer dollars for childbirth-related services? And the Supreme Court said, no, the state can't preference one pregnancy outcome, carrying to term, over another. And so further, they said that the Minnesota Constitution, which guarantees our right to privacy, that the Minnesota Constitution in Doe v. Gomez, they found that Minnesotans have the right to have an abortion and decide to have an abortion without the government interfering. And the right to have an abortion meant that abortion is legal in our state. And the right to decide to have an abortion meant that the government may not put its thumb on the scale in favor of one pregnancy outcome over another. They didn't want to try to sway people one way or the other. And because the right to privacy is a fundamental right, it's a constitutional right in Minnesota, the court would apply strict scrutiny to any laws infringing on that right. What is strict scrutiny? Well, I'm going to show you here. There are a number of ways that courts assess laws. And when we talk about strict scrutiny, it's the highest level of scrutiny that courts would give laws. And they ask, are these narrowly tailored laws for a compelling state interest with no less restrictive alternative possible? And this is where we have constitutional rights, right? If you have a constitutional right to something, you want to make sure that any law that infringes on that is really narrow for a really good reason, and that there was no less restrictive way to write that law. And so I just want to show all of you, when we did polling in 2019, we found that 70% of Minnesotans agreed with that ruling. Do you disagree or agree with the ruling from the 1995 court case? 70% agreed. Despite that happening, we have a whole host of abortion restrictions in the state of Minnesota, including a mandated medically irrelevant and biased script that doctors were provided or were required to read to patients. We limited the pool of providers by preventing advanced practice clinicians from providing care. There was a 24-hour waiting period and medically unnecessary appointment. There was a mandated fetal tissue cremation or burial. And there was a two-parent notification scheme for minors, regardless of a minor's relationship with one or both of their parents. And many of these restrictions were actually enacted in 2003, so almost 10 years after that 1995 court case. And when we did that polling, we asked Minnesotans, do you know about any of the laws in Minnesota? 96% of Minnesotans did not know one law. And we were very, very generous. If they said, we have a waiting period, we gave them credit for that. So we have strong constitutional protections established in 1995. We have 70% of Minnesotans agreeing with that case. And then we have a whole host of abortion restrictions that are passed into law, of which 96% of Minnesotans don't know. And after Trump was elected and Brett Kavanaugh was confirmed to the Supreme Court, it was very, very clear that the abortion rights fight was going to move to the states. So enter Doe v. Minnesota, which was filed on May 29th, 2019. So, 3 years ago, this was filed. And in this case, we had plaintiffs, the First Unitarian Society of Minneapolis, and I'll let Papis address the asterisk there later, Our Justice and Abortion Fund in the state, Dr. Doe and Mary Moe, two anonymous people. One is an abortion provider and one is an advanced practice clinician that would like to provide abortion care. And we challenged those laws that I showed on that screen, the physician-only law, the 24-hour delay and the biased counseling, the requiring of burial cremation, and the two-parent notification scheme. And our arguments were really simple. These abortion restrictions were out of step with contemporary medical practice. They ran contrary to our strong constitutional protections, and they failed to honor the diverse religious traditions of Minnesotans. So Monday, today's Wednesday, Monday, we got summary judgment in our case, and it was great news. And I'm going to turn it over to Papis to talk more about that great news and what came out of our summary judgment. Papis?
Thanks, Erin. So if we can go to the next slide. Yeah, thank you. I'll just give a brief explanation on what summary judgment is for all the non-legal folks out there, so that you know what exactly has happened. At its basic, summary judgment is an opportunity for the court to decide legal issues without the need for a trial. And so if the court decides that there are no issues of material fact and contention, it can decide the issues for one party or another. And so that's the decision that we got on Monday. And so Monday's decision is a final judgment, and the court's permanent injunction is immediately effective. And I'll just say an injunction is essentially saying that the laws are blocked, they cannot be enforced. So in its decision, you see here some big quotes from the court. And that first one there, I'll just point out, the right to choose to have an abortion would be meaningless without the right to access abortion care. Obviously, we know that to be true. We have known that for a long time, not just in Minnesota, but throughout the country. The court's recognition, not only that this is the case, but that this is what the Doe v. Gomez court stated, is really huge. And of course, the court departed from what has happened in federal law lately. Unlike the Dobbs court, which throughout nearly 50 years of precedent, this court must respect the precedent set by the Minnesota Supreme Court in Gomez. I think what we're seeing here is strong protections from the Minnesota state constitution. So thanks, next slide. So what actually happened in the summary judgment decision? Here are the laws that were permanently enjoined. So again, these laws are blocked. This permanent injunction is immediately effective. And I'll say, a lot of these laws, obviously they are unconstitutional and they will help access, but I think this is especially important given now with the influx of patients that may be coming to Minnesota. And we'll have folks talking more about that in a second. But I do want to flag really quickly the only law that we did lose on was the reporting requirements. So abortion providers having to report certain information about the care that they provide, their patients, et cetera, to the Department of Health, and then the Department of Health publishing that data annually. We did lose on that. However, the felony penalties that you see there at the end, number 7, those are no longer used to enforce the reporting requirements. And so that is still a win there. The only other law that isn't here that Erin mentioned earlier is the fetal tissue disposition requirement. And we didn't lose on that law. The court seems to have misunderstood some of the earlier procedure. And so if you remember the asterisk next to the First Unitarian Society that Aaron mentioned, earlier in the proceedings, the First Unitarian Society actually voluntarily dismissed itself from the lawsuit. I won't get into all the little details about that, but ultimately it was a decision to help move the case along more quickly and get to a final judgment and get some relief as quickly as possible. So even though the claim that FUS had brought against that fetal tissue disposition requirement, that is dismissed. That was a religion claim. There are still other claims brought by the other plaintiffs that are still live against that disposition requirement. And so, we can do some follow-up with the court. We can still get some relief, and hopefully, based on the decision we got Monday, that is good news for how the court may decide on the disposition requirement as well. But for now, that law is still in effect. So I will pass it off now so we can hear more about the impact that Monday's decision will have on access in Minnesota.
Thank you, Papis. And I do want to answer one question that we have in the chat, which is there a single parent notification required or no parental notification whatsoever? This eliminates the parental notification altogether. And there was an earlier question about what other healthcare can minors consent to. The way that the law is written in Minnesota, minors can consent to a whole host of healthcare, including giving birth, STI treatment, substance use disorder treatment, so on and so forth. Abortion was actually accepted from that law. And so now with this two-parent notification scheme gone, minors can access abortion care the same way that they can access all the other healthcare that they're allowed to access in law. Did I answer that correctly, Papis, the actual lawyer?
Yeah.
Sorry, I was muted, but yes.
Okay, wonderful. And then there was one other question, Papis, I'll send to you. It's, can this decision be challenged?
So this decision can be challenged. The state has 30 days to appeal this ruling. We won't know probably for a while if that will happen, but regardless of whether the decision is appealed, we believe that this decision was correctly decided based on precedent from the Minnesota Supreme Court. And so, we feel confident that any appeal would also go our way. There is also a possibility that pending appeal, the state might ask the court to stay the decision or pause the decision, meaning that all of the enjoined laws would go back into effect. We would push back on that request if that were the case, but yeah, so it's still too early to know what if anything will happen, but we'll know more in the coming days and weeks.
Thank you. And then there was another question about, does this decision only mandate acts in Ramsey County? A 6th district judge said that technically this decision only covers Ramsey County since the judge is not a U.S. district court judge. Can you speak to that?
Did I hear correctly at the end, since the judge is not a U.S. district court judge?
That's how the question was phrased.
Understood. Yeah, so I'll just quickly say, yes, this is this injunction is statewide. And just to that last bit of phrasing, that would make it so a U.S. district court judge would sit on the federal bench, and that is irrelevant here because this lawsuit was brought in state court under state law, and so that last piece wouldn't affect it. But yeah, this injunction is statewide.
Awesome. I think. One more legal question. I'm going to come back to you. Is the felony penalty lifted? So what is the penalty for not reporting? With the felony penalty lifted, what's the penalty for not reporting?
Yeah, so this is this is one of the keys to the argument against the felony penalties, and it's that the medical profession is, beyond abortion providers, is regulated in a particular way. There's administrative penalties, there's civil enforcement, there's professional discipline. There are all these enforcement mechanisms already in place. There was no need to have felony penalties in addition to that, only for abortion providers. And so in the absence of the felony penalties, abortion providers are now just like any other healthcare providers, and they are regulated in much the same way.
Awesome. So I'm going to actually turn it over to Shayla and Christy to talk about the impact that this is having on the ground.
Hi, everybody. So right now with the fund, it's only been a couple days, and so it's really difficult to decipher what kind of impact it's having. As you all may already know, people make the choice to come to Minnesota for a whole host of reasons. It's not just because it's easier to get an abortion here because the 24-hour waiting period has been lifted, but maybe because they have family here, maybe because they can get an appointment here, maybe the stars aligned where they were able to get childcare and take off of work. So all those factors are also going to, in addition to these, the fall of these restrictions, are going to contribute on if people decide to come to Minnesota. So like I said, it's really too early to see the impact, but we are prepared and ready to take on all patients who are coming to Minnesota and who need care through the abortion fund. And I'll pass it to Christy.
Thanks, Sheila. I think I'm going to amplify what Sheila said. We are all figuring out what this means at our local sites and where we provide this care, and all of our compliance and attorney type folks are helping us sort that out. But we are really hopeful that especially for folks really that need to access care here, whether they're Minnesotan or well beyond, this will help reduce the barriers that people already face. In different sites, people interpret laws differently with their risk tolerance. And so I think it's important to reduce as many barriers as we can. I can't tell you how many times I've tried to call people to do the 24-hour mandated wait and can't get a hold of someone, or we need to call back with a different type of interpreter, and then we can't reach folks. And so this removing that step is really important. This is a huge win for minors. Can you imagine being a 14-year-old person and that couldn't disclose their plans for abortion care to their trusted adult in their life, and having to navigate a court system by themselves? No. So this allows us to be able to help those minors in a more expedient fashion. And that's always better for people. Having your abortion as soon as possible is always the best for that pregnant person.
I do want to just read a bit of the judge's summary judgment about the two-parent notification scheme for minors. He said, minors who undergo the judicial bypass experience fear intimidation, as well as the gamut of shaming and harmful responses by authority figures, including judges and guardians ad litem. And so I thought that was just a really good way of putting how that experience would be for minors. There's two questions.
And for folks from marginalized communities trying to access this care through the court, I mean, it's just, that's not how we should be doing this.
Yeah, jumping on what you just said, Christy, I wish this decision would have came out about 2 weeks before. We had a minor who was undocumented, who was trying to get to their appointment, and their appointment just kept getting pushed because there were no guardian ad litem appointments. They were Spanish speaking. We were trying to find an interpreter, trying to find a ride. Then she got confused, thought she had to pay to go see the judge. We had already covered her abortion, and I don't know if she's ever gotten seen. She never got a call back to us. And yeah, it's just really hard to be in the process of helping somebody navigate that, and then they just kind of fall off the grid because they decided this is just too challenging, it's too hard, there's too many hurdles. And now I'm just happy that somebody doesn't have to go through that. They can call the clinic, they can get their funding directly through the clinic and through our justice and be seen.
And it's hard for, especially for minors, it's hard for us, so I'd have colleagues ask me, well, oh, then you like help them get to court, right? And if I do that as an abortion provider, that looks like I'm trying to coerce a minor into ending their pregnancy, right? So we functionally couldn't do that. And this, again, how hard of a therapeutic relationship that is to develop with that minor then if you're like, well, I can't help you with this part, And so that piece going away is we are hugely excited about it.
Yeah.
There's
we had a lot of volunteers who are willing to help minors, but volunteers are volunteers and they're only available when they're available. And so it wasn't a consistent thing that was available to folks. I'm also thinking about 95 counties in Minnesota doesn't have access to abortion providers. And now advanced practitioners are going to be able to provide abortion care. That means like people are going to be able to be seen in their communities. They don't have to cluster in the Twin Cities. They don't have to cluster around Duluth. We can spread the work out through many providers across the state. And so I'm really excited for what that means for people accessing care. They don't have to drive so far.
That actually is a perfect segue because there's two questions that are kind of similar. And I think this is going to go to you, Christy. What kind of training and other steps need to be taken in order to expand the number of providers for abortion services now that these restrictions are overturned?
I think there are multifacets of providing this care. I think for people familiar with providing healthcare, it's really not that big of a leap, especially when we're talking about medication abortion. There are lovely training tools already available and free on the web. And most of us that do this work are happy to help mentor folks. It's just getting coordinated and getting the pills and all of that stuff lining up in a row. I think for procedural abortion, it's a little bit different, and that will come with time. But we're excited now that we have the capacity, the legal support to be able to start offering that.
Yeah, and just to be really candid, right? Medication abortion is 2 pills. It is safer than over-the-counter Tylenol, and so the training to get up to date to dispense 2 pills won't take nearly as long, and it'll have a huge impact. Megan, did you want to add anything to that?
I just want to note there are organizations, including who are members of the Unrestricted Minnesota Coalition, who work to support providers who need training and to get connected into the process of becoming a provider. So the Reproductive Health Access Project and their Twin Cities-based cluster is a part of the coalition, and I know they're already working with providers and with nurses who we've been building relationships with over the past 3 years of this lawsuit and campaign, who are very excited now to be able to be on that road to being able to provide. And so yeah, we're thrilled that we get to kind of move to that phase of the process and hope that it'll be a meaningful expansion on the ground, like really, as soon as possible.
And there was a question to clarify the difference between parental consent and parental notification. In Minnesota, we were the only state in the nation that had 2-parent notification. So minors were required to notify both of their parents by certified mail that they were going to access abortion care, regardless of their relationship with the one or both of their parents. And sometimes the difficulty really was not just notifying both of your parents, but proving that the people you were notifying were in fact your parents, right? So let's say you have a different last name, or your parents are divorced, or whatever, and you have to find a marriage certificate and a birth certificate and a divorce decree. You're finding all of these things, or if you have a deceased parent, a death certificate. So that whole scheme was really, really complicated, even if a minor was comfortable notifying both of their parents. And so oftentimes minors just ended up in front of a judge asking for permission to get an abortion because of how complicated it was to notify both parents. I am going to check with, I'm checking in the chat to see if there's any more questions just about impact on the ground. Medication abortion by mail, are there any updates? I know it's been back and forth on this access since the pandemic. Go ahead, Christy.
Yeah. We, in all of the places I work, we are mailing medicines.
Yep, we can get
and
medication.
We serve a lot of different clinics that do medicine. We serve the local clinics as well as national clinics and providers that mail medicine. So it's been on our end, it's been a pretty seamless process to provide funding to patients who need medication abortion.
How can APPs start providing abortion care?
Stay tuned.
Yep, lots
I
of
think
things.
again, people are just sorting out the actual language in the decision from Monday, and when that's done, we will have a plan.
And I think that this has been answered, but I'm just going to make sure. Does this open up the possibility of midwives or legally practicing unlicensed traditional midwives to be able to provide or facilitate abortions legally? I think those might be two different questions.
I mean, there has and always will be community-based abortion care in our communities, and so I am not a lawyer and am not going to speak authoritatively about what that means or whether or not that will come down to midwives that are licensed in Minnesota or not.
I think there's some legal questions I want to come back to you, Papis, for. Some of them are around the Attorney General. So should we be contacting the Attorney General's office right now? Or what are the reasons that the Attorney General could choose to challenge or not?
So as to that first one, I don't see any reason why the Attorney General would be contacted. I mean, I'm not sure who this is from, but I don't see any reason to contact the Attorney General. And I'm not going to comment on things sort of outside the legal process because right now, with this summary judgment decision, though it is a final judgment, the litigation is still ongoing. There is a potential appellate process, and so that goes to the next question: what are the reasons for which the AG might appeal? And I'm not in the Attorney General's head or in his office, so I don't know what kind of discussion is happening there. I know they're reviewing the decision, but I would I think the most obvious answer would be the same reason that they're defending the challenge laws, and it's that there's that constitutional duty. Because again, the litigation process is still ongoing, even though we have a final judgment. So I think that's about all I can say to those questions.
Yeah, it's a normal part of litigation for there to be appeals, I think is part of that.
Well, sorry,
go ahead,
Mary, and also if I can just add, it's the role of the Attorney General to defend state laws. So, if they do choose to appeal, I don't think people should overly read into that's the Attorney General doing the Attorney General's job. So we, like Pippi said, we don't know what they're going to do, but yeah, that's just, everybody kind of has their role and their job to do, and that's the Attorney General's job. So
yeah. There's a question that says, are there other restrictions that prevent clinics and hospitals from providing abortion? Abortion specific clinics do a great job, and why can't we receive this care at our routine clinic or hospital? And I think there's a bunch of people who can answer this, but one thing I want to say is that the restrictions that were removed were working together in concert to both intimidate physicians and providers of abortion care, right? They would be subject to felony penalties for not submitting the age and race of one of their patients that they provided care to. It's been stigmatized. It's hard to get training. They've limited the pool of people. And so they all worked together to reduce access in the state of Minnesota. And that's why it wasn't received at routine clinic or hospitals. And removing these restrictions certainly opens up those avenues for that to happen. But I will also let Christy, Megan, Papis, Shayla speak to that as well.
Well, I can go. I have a lot of thoughts about that. I do provide abortion care in a hospital. So it does happen. It happens in many hospital systems at least in our metro area. I think but what Erin was saying is that there's been fear and restrictions, and it's probably not brand new information to any of you on this call that abortion is essential healthcare that is highly politicized, and people view it as black and white, and it's just not. It's just when you honor and center the lived experience of people who need it, you realize that it's not. So I think there's a lot of groundswell and a lot of momentum in many of the hospital systems, at least again in the metro area, that are that really kind of kicked off after the Dobbs decision on June 24th, to try to fix that.
I want to be mindful of your time, Chrissy. So I think I have one more, which is, when will HCMC or Hennepin Health, the largest public hospital in the state and a major teaching hospital, begin providing abortion care?
I don't work there, in full disclosure, but I know many people who do, that are actively working to try to start doing that.
Awesome.
And that's about all I can say about the details.
Shayla, this one might be a good one for you. What are things people can do at local governments to help expand access?
I think just reaching out to your representatives, your local representatives, letting them know that that's something that's in your heart, that's something that's important to you. Our Justice and Pro-Choice Minnesota, we have been working behind the scenes to get something pushed in Minneapolis and in St. Paul, in terms of making sure that reproductive justice and reproductive care wraparound services, including abortion funding, are in the city budget. It's a slow but steady conversations that we're having with local government, but just putting a bug in your ear, reaching out to your representatives, letting them know this is something important. And then once we hit the ground running, we will be reaching out and letting y'all know what else we need. But right now, we're just kind of in the preliminary steps of doing that municipal work.
And I will also just say that we have a doctor who's at HCMC who said soon. So the answer to the HCMC question is soon, which is very exciting. There was a question about becoming a housing providers for people coming in from out of state. Shayla, do you want to talk a little bit about what folks can do to support people who will be coming in from out of state?
Throw a house party to raise money for our justice. Across the nation, we've been in talks with other abortion funds, other practical support groups, and we know with the heightened hostility around abortion care and what the feedback that we receive from the people that we serve, it is just a safer option to have them in hotels rather than people's homes. It's a safer option for people as well, because right now, although there aren't any laws to my knowledge that say that, you could get in trouble for housing somebody, who knows what can happen next week, next month, in a couple months. So we need to make sure that we're protecting both the patient and the volunteer. And so protecting their privacy means that we're setting up hotels. We work with an organization called Safe Stays, and they do hotel stays, anonymous hotel stays. And so again, that's protecting the privacy of the patient and the people that are traveling with them, because we know that most people who are accessing abortion care already are parents, and they're traveling with their loved ones, they're traveling with their children. And it's important to protect their privacy as well. So through a house party, fundraise for us, and we will make sure that they have a safe way to get here. I would say also fundraise for Midwest Access Coalition. Midwest Access Coalition are the ones who are buying bus tickets, plane tickets, train tickets, and providing gas cards for people traveling to and from other states. Then you could volunteer with Spiral Collective. Spiral Collective is a local organization, very, very small, volunteer-led. They're only on Instagram most of the time, but they do abortion doula trainings. They do transportation trainings, so they provide transportation in the metro area. But yeah, if you're looking to support transportation in the metro area, throwing a house party to raise funds for the hotels here, throwing a house party to raise funds for traveling and giving the money to Midwest Access Coalition. Honestly, it's a lot of logistical work, a lot of steps to make sure that somebody gets from A to B safely and securely. And we have a lot of people who've been doing this for a long time who just need money to do it.
A question in the chat: should clinics be waiting to stop performing 24-hour waiting periods, or should we wait to see how legal teams proceed? Another person said, right, this is also my question. Can I tell my minor patients that the notification law is null as of now?
So I'll just reiterate a few things. The permanent injunction is effective immediately. I don't want to give any specific legal advice over a webinar like this, but if you have any specific questions about compliance, you should feel free to follow up. I can put my email in the chat.
Great, thank you. There are some questions about what we do next, and that's coming up next. I think some of the last questions about legality are we considering appealing portions of summary judgment that we lost?
I'm gonna have to give you a non-answer to that. We're still discussing any elements that we might potentially want to appeal or not. I can't really say here.
That's fine. There is a question that I would like to answer. Is there anything we can do about the anti-abortion fake health centers? Can we sponsor something to stop giving them state money? You can contact your legislators. So there are 98 fake health centers in Minnesota, or crisis pregnancy centers. They receive about $3.5 million per year of taxpayer dollars, and they are explicitly set up to dissuade people from accessing the healthcare that they need and deceive and stigmatize patients. And so this is done through a grant program through the state of Minnesota called the Positive Alternatives to Abortion Grant Fund. That money could be well used to actually support free services for pregnant people, whether it's prenatal care or resources or abortion care. And so you should contact your state legislators, your state representative, your state senator, and say that you would like the money that's in that grant fund to actually be going to groups that actually provide resources to pregnant people. That's not biased. It's not trying to sway them one way or the other, but providing them real services and real care that they need. Megan, you hooed, and I would love for you to answer some more too.
Yes, it's such a good question. And yes, there's a lot that can be done. Last fall, Gender Justice with some of our partners in other parts of the country put out a report called Designed to Deceive. It's a study of the crisis pregnancy center industry in 9 states. There's a lot more information there, but we also have a bill that we're looking forward to introducing in January that is called the Positive and Supported Pregnancies Act, and it would repurpose the alternatives program to do what Erin is saying. And so keep your eye out for that. It is that bill is also within the broader leadership agenda for abortion access that we released in partnership with the Reproductive Freedom Caucus on it turned out to be Decision Day, the Dobbs Decision Day, that we also released that agenda. But that bill is a part of the agenda. And Erin, I don't know if it makes sense to transition to talking a little bit about the agenda now.
I think so. It's literally my next slide. So I'm going to share my screen again.
And Sandra, I'll just say, keeping up with the bill, Erin Hart just dropped the link in the chat to support the agenda, and that will also make sure that you get updates from us on next steps. Next year, with any luck, we'll be in a position to advance this agenda that we're going to share with you right now through the legislature, and we will need all hands on deck for that because it'll take a lot of work to get this next phase of what needs to happen through the legislature. So EMQ, do you want to go to the next slide? Awesome. So we released with the Reproductive Freedom Caucus in the House and Senate, Minnesota Beyond Roe, the leadership agenda for abortion access that really lays out what next. Roe is overturned. People are traveling more and more to Minnesota. What does Minnesota need to do to really meet the moment that we're in and create the conditions that would allow for true and full access to care? And the first bucket, there are three sections of the agenda. The first one is to repeal restrictions, which I think for the most part we can, on lots of these we can say done. Like we did that through the courts as of Monday. However, we will, I know from already hearing from the leaders of the caucus that they're interested in still running bills next session to remove those laws from statute, so that if the courts change in the future, they won't, run the risk of becoming live again. So we're excited that there's interest in still moving legislation to fully remove these laws from our books. But very happy to have unrestricted Minnesota in some really meaningful ways already. Go ahead, EMQ. And then the second priority area is to enact protections for patients and providers from post-Roe attacks from anti-abortion states. We have already seen the anti-abortion movement move really quickly to try and figure out how to reach across state lines into states like Minnesota that do have state level protections for abortion, to try and follow their state citizens, across state lines as they seek care. And so, the components of enacting protections include codifying a right to all reproductive health care and being able to make your own reproductive health decisions in state law. So that's through the PRO Act. And then to pass the Reproductive Freedom Defense Act, which was introduced at the end of session this summer. And that is specifically designed to try and make sure that anyone who either receives care or provides care in Minnesota, cannot be criminalized or, face civil penalties back in their home states for doing so. And then also to ensure that we're protecting people and keeping people safe from criminalization who manage abortions on their own. We know that with the influx of patients, there is absolutely the potential that people will self-manage using medication, at home outside the medical system. And if and when that happens, we need to make sure that they aren't facing a risk of, going to jail for it. So that's that second bucket. The third area of priority is honestly an area that was extremely important even before Roe was overturned, and that's to ensure affordability and equitable access to care. And so this is where you'll see the fourth bullet there speaks to that bill to repurpose the Crisis Pregnancy Center funding program. But this also addresses things like the really terribly low reimbursement rates for abortion coverage that providers contend with, and that puts a lot of them at risk of being able to keep their doors open. This also calls for the state to fund abortion funds to help people who don't have health insurance or can't afford the associated costs with seeking abortion to be able to have funds to make that happen. And we're just really excited about having the support of the Reproductive Freedom Caucus and hopefully being in a place in January to move this agenda forward and kind of keep up the momentum of our win on Monday towards removing other financial and legal obstacles to care for Minnesotans and for people traveling here for care.
Megan, could I just interject 1 second
Yeah.
too? I think it's really important to note too, that the majority of the people that our justice serves, they do have health insurance. A big chunk of them have health insurance. It's just that the health insurance is not covering abortion. So I just want that to be known, because I think a lot of folks think, oh, like a lot of people running around here with no health insurance. Yeah, there's a lot of people out here with no health insurance, but a lot of them do have health insurance, have high deductibles that they cannot meet, or their insurance just decide not to cover it, period. And so that's another thing that we're trying to address, making sure that insurance companies cover the abortions.
Yes. Yeah. Unfortunately, right now, none of the plans available on MNsure, if that's how you receive your health insurance, none of them explicitly cover abortion. We have heard sometimes people do manage to get abortion covered through those plans, but if you go to look for a plan on MNsure that you can feel confident will cover elective abortion, you can't actually determine that through MNsure. And we think that you should be able to know that you're buying into a plan where that would be provided. So that third bucket also addresses some of the insurance coverage issues that we think the state could do a lot better on.
Megan, do you want to just talk a little bit about this next slide about abortion and democracy?
Sure, I would love to. I think, we just wanted to name, I'm sure everyone is following a lot of news, not just related to reproductive rights, health, and justice right now, but, the attacks on abortion are not unrelated to the challenges we have in our country around democracy overall. And I just thought, Erin, maybe you could pick up for me since I'm having dog issues.
Not a problem. Yeah, I mean, it's really clear that, having autonomy and agency over your body is actually a really core part of democracy. And so, we pulled this quote from a thing that it's not a coincidence that when abortion access goes down, authoritarianism goes up. Those are two interdependent and intertwined things. And so as we think about, this fight nationally and in the state of Minnesota, we know that it is absolutely about abortion. It's about bodily autonomy and agency, the ability to decide if and when you become a parent. And it is also intertwined with the bigger fight for our democracy and for the survival of this country as we know it. And so I think we can understand that as we see nationally the backsliding that's occurring from the Supreme Court in Minnesota, we actually took a step to protect this right, this fundamental right, and that is inherently in protecting our democracy here in the state of Minnesota. And so it's important that we name that and that we bring that forward and talk about wins that we have, because there's not a lot of those nationally right now. I'm also going to talk about things that folks can do, that you all can do, right? So Shayla talked about hosting a house party and donating to Our Justice and really helping people access services. Abina, do you want to talk about the rally?
Sure. So we are going to be gathering on Sunday for a rally and march, starting at St. Paul College and ending at the Capitol. This will be a good opportunity for you to be out with us and other folks in community talking about how exciting our post-Roe agenda is and getting people fired up to get geared up to not just vote, but also to join us in holding folks accountable once they're elected at the legislature to pass this agenda. So we hope to see you and your friends on Sunday.
Wonderful. And this will be really important to both show ourselves in numbers and also grab folks when they're most energized so we can actually pass that agenda, because this is the start, not the end. And I'm going to stop sharing my screen because there's just a few more things. Signing on to the leadership agenda, which I think someone put it into the chat. So sign on to that. And then making sure that you're following groups on social media and donating. So co-sponsors of this event today, Gender Justice, Our Justice, the Lawyering Project, Unrestrict Minnesota, and Whole Women's Health Alliance, crucial partners in protecting and expanding access to abortion care. Talk to your friends and family, share your stories. We're working to destigmatize abortion, and 1 in 4 people who can get pregnant are going to have abortions in their lifetime. This is a really common healthcare procedure that people have. It's part of pregnancy care. And so the more we talk about this, the more we share our stories, the more we remove that stigma. I do want to get to some more questions, but do Abina or Shayla or Megan, do you want to jump in with any additional things people can do?
I will just because the whole thing about housing came up, I just want to remind folks about mindfulness in this moment. I know that everything seems scary and all over the place, but folks that are making the decision to have abortion care have a support system around them. And so please be mindful and not make things awkward by offering to hold people's hands through the process or opening up space in your home. Like, this is a process that people put a lot of thought into, and they create intentional community as they go through it. And if people would like you to be a part of that, they will reach out. But it is awkward for folks to have to turn down help sometimes. And so just check yourself and just be mindful and make sure that you're not overstepping your bounds when trying to be supportive of others.
Thank you, Abina. There are a few legal questions that I want to come back to you, Papis. Would it be more beneficial to have a Supreme Court decision affirming this ruling? And is there any risk that the Supreme Court may find that because the US Constitution doesn't provide a right to abortion, our state constitution can't provide more rights than no rights?
Great, so I'll take that second question first. And actually, this would be really helpful if you could put up the slide 14,
Yep.
just so folks can have something to look at. And so this is language from the district court in Monday's summary judgment decision. So the Minnesota Supreme Court has interpreted the Minnesota Constitution to offer greater protection of individual rights than the United States Supreme Court has afforded under the United States Constitution. And I just want to flag, that is not something that the court sort of just made up on its own in its decision on Monday. That is directly from the Doe v. Gomez decision back in 1995. That was the Minnesota Supreme Court. So they have already decided that. And in that opinion, the Doe v. Gomez opinion, there was a lot of discussion from the court about how the US Supreme Court has treated the right to obtain abortion care. And explicitly, the Minnesota Supreme Court departed from that reasoning and those decisions, and decided that access to abortion care is a fundamental right and it should be protected as such. So no, long story short, nothing happening with Dobbs is going to in any way diminish the protection provided by the Minnesota Constitution and the Minnesota Supreme Court. Could you repeat the other question?
Yeah, would it be more beneficial to have a Supreme Court decision affirming this ruling?
Not really, and I think it's largely for the same reason. The district court in Monday's summary judgment decision wasn't making law, and that's also why we feel strongly that if any appeal goes forward, we will still prevail. What the court was doing was applying well-settled Minnesota constitutional law. So again, that decision from 1995, Doe v. Gomez, that is already well settled. So in short, no.
Yeah, would it be accurate, Pepys, to say like this was, a strong constitutional protection already decided, already here in Minnesota, it just hadn't been utilized to remove restrictions that were passed after the decision came out.
Right. Like over time, following the Doe v. Gomez decision, over time, these restrictions built up and they could have at any point been challenged under that same legal reasoning. The fact that they weren't and therefore were in force does not mean that they were constitutional. And so, yeah, this is already well settled Minnesota constitutional law.
There's a question about the changes. Are there any changes to the cremation requirements? Do you want to explain kind of what happened there?
Yeah, I'll say a little bit more about that. So this is the requirement that that following an abortion, the fetal tissue must be disposed of either by interment, so burial, or cremation. And this lawsuit brought a number of challenges against that law. And so there were a couple of claims. The one I mentioned earlier, the religion-based claim, that one was from the First Unitarian Society, which as I said, voluntarily dismissed itself from the lawsuit for reasons I won't get into, but it had to do with trying to move the lawsuit along as quickly as possible, especially after Dobbs came down. And so the claim against that disposition requirement that was only brought by FUS, the religion claim, that one fell away. That claim was dismissed. But the other plaintiffs that still are in the lawsuit, they also brought other claims. So chiefly claims based on privacy and claims based on equal protection. And so those claims are still in play. And so, I think the court was just mistaken that all of the claims had been dismissed against that particular law, but that's not the case. So for now, that law was left out of the laws that were permanently enjoined. It may take a bit of time to get that, to bring this to the court's attention. We hope that based on the legal reasoning that we see in Monday's decision, that it will also hold that that law is unconstitutional. But we can't say for sure until it happens. For the moment, that law is still in effect.
Thank you, Christy. I appreciate you giving us your time. Yep.
Sorry, gotta go.
Yep. Go provide care. Pippies, there's kind of two questions that are kind of getting at the same thing. And I think it's fear around, we thought Roe was settled law, and now given the right set of circumstances, it was overturned. So how is settled law in Minnesota different from settled law at the federal level? And similarly, does this decision strengthen Doe v. Gomez against future attacks by anti-abortion legislatures or governors?
Yeah, so I'll just say Roe was well-settled law. In the time since Roe, there have been many abortion-related decisions that have come down, not only from the U.S. Supreme Court, but various appellate courts throughout the country, district courts throughout the country. And what you saw was a concerted effort nationwide by anti-abortion advocates to try to continually pass laws to sort of put Roe to the test, right? See if we can chip away at it in any way. And what you've seen, especially in the last, 10 years or so, even though this is certainly a decades-long effort, is that the federal bench started to change, right? And particularly in the last 5 or so years, we saw a massive shift in the federal bench, and especially at the US Supreme Court. And so, it can be easy to forget that institutions are made up of people, and that's how you end up with well-settled law still being overturned with Dobbs. Could that happen in Minnesota? Yes, I suppose. I think the same kind of strategy could be put into effect in Minnesota by anti-abortion advocates. I think that's why it's important to say, Monday was a great decision. The 1995 Doe v. Gomez decision was also great. But that's not the end of it, right? Like there may still be attempts to continually try to chip away at that politically, but in ways that could still affect the legal processes. And so, I would say, it's never over.
And I think this is an important place for me to say judges in Minnesota are elected. So when you vote, which you should all be voting, you need to flip over your ballot and vote for judges. And in Minnesota Supreme Court judges are appointed by the governor. And then 2 years after they're appointed, they stand for election. And so it's not just like, finding the right people to go to law school and become judges. It's also literally about voting. It's about voting for judges on the ballot. It's about voting for the governors who appoint Supreme Court justices. They all have to retire at the age of 70. So there's constant turnover on the bench as well. And so that is when Pipis talks about, a shift in landscape on the bench that could happen in Minnesota. It's why we have to be really aware of how that could happen. I'm really aware that we are getting close to the time we said we would let folks go. There was a question about gestational age. There was a really great MinPost article written about that that's going to be posted in the chat. It's not a really cut dry answer. It's a little bit complicated. And Abina, there was thanks for you for bringing in, asking folks to be mindful. I think we've gotten to most of the questions. I want to thank you all for joining us this afternoon, spending an hour with us, learning about this great victory in Minnesota and all the great work that's been happening over the last 3 years to get us to this point. Thank you so much for every piece of support you've given us, but the fight is not over. We still have a lot of work left to do. So join us at the rally. Join the mailing list, donate to our abortion funds and our clinics, and let's get this post-Roe agenda passed in Minnesota so we can have a place where pregnant people can access the full spectrum of the pregnancy care that they need. Thank you so much, everybody.